On the June 5, 2026, the Pretoria High Court did something extraordinary. It ruled that international airlines flying into South Africa do not have to comply with B-BBEE, not because the court is anti-transformation, not because it doesn't care about history, but because the law that governs international aviation says nothing about race. And the regulator had been demanding B-BBEE certificates anyway, for years, from airlines from America, Europe, Asia. And when they were challenged, the government withdrew its opposition. They didn't fight, they couldn't, because they knew they had no legal basis. Now ask yourself, if B-BBEE is so constitutionally sound, so morally justified, why did the government run away from this fight? That is the question this video answers. And the answer is going to make you angry. Not because I'm telling you something you don't know, but because I'm going to show you, with the text of the Constitution and the B-BBEE Act in hand, that the entire edifice of black economic empowerment is built on a lie. It is discrimination, pure and simple, and it violates the very document it claims to serve. Here is the first micro-reward, the thing you did not know. Section 9 of the South African Constitution prohibits unfair discrimination. It says the state may not discriminate on the basis of race. Section 9(2) creates an exception for measures designed to advance persons disadvantaged by unfair discrimination. That is the constitutional hook upon which B-BBEE hangs, but the exception is not a blank check. It is subject to Section 36, the limitation clause. Any limitation of a right must be reasonable and justifiable in an open and democratic society. It must be proportional. It must be the least restrictive means. B-BBEE is none of those things. It classifies people by race. It allocates benefits and burdens by race. It does not measure individual disadvantage. It assumes that all black people are disadvantaged and all non-black people are privileged. That is not a nuanced remedy. That is a sledgehammer. And sledgehammers are not constitutional. Now let's look at the B-BBEE Act itself. Section 1 defines black people as a generic term meaning Africans, coloreds, and Indians who are citizens. That is a racial classification. The Act does not ask whether a particular black person is wealthy, educated, or connected. It does not ask whether a particular white person is poor, disabled, or struggling. It simply says, you are this race, so you get the benefits. You are that race, so you bear the burden. That is not transformation. That is racial discrimination. And the Constitution says discrimination is unfair unless it is established that it's fair. The burden is on the state to prove fairness. And the state has never met that burden. Not once. Because you cannot prove that discriminating against one group to benefit another is fair when the discrimination is permanent, when it applies to all members of the group regardless of circumstance, and when it entrenches racial categories rather than transcending them. But here is the pattern interrupt, the United Nations Charter. Article 1 of the Charter says the UN shall promote human rights and fundamental freedoms for all without distinction as to race. Article 55 repeats that. Article 56 obliges members to take action to achieve those purposes. The International Convention on the Elimination of All Forms of Racial Discrimination, which South Africa has ratified, defines racial discrimination as any distinction, exclusion, restriction, or preference based on race which has the purpose or effect of nullifying human rights. It permits special measures only for the sole purpose of securing advancement, and only if they do not lead to the maintenance of separate rights for different racial groups and do not continue after their objectives are achieved. B-BBEE is a distinction based on race. It nullifies the rights of non-black people. It is not temporary. It has been going on for over 20 years. It creates permanent separate rights. It is by any definition racial discrimination, and it is incompatible with the UN Charter. South Africa is a signatory. It is bound by international law, and it is violating that law every single day. Now, let's go back to that court case. The International Air Services Act governs the licensing of airlines. It says nothing about race, nothing about B-BBEE, nothing about transformation. It talks about safety, reliability, financial capacity, operational standards. That's it. Yet the regulator, the International Air Services Council, was demanding B-BBEE certificates. They were asking for transformation plans. They were threatening to deny licenses. Why? Because they could. Because no one had challenged them. Until Sekeliga came along, and when they did, the government folded. The Minister of Transport withdrew her opposition. The regulator withdrew its opposition. They didn't even put up a fight, because they knew they had no legal basis. They were just hoping no one would call their bluff. And when someone did, they ran. This is the third wave of B-BBEE. The first wave was voluntary. The second wave was linked to state contracts. The third wave is regulators trying to make B-BBEE a prerequisite for any economic activity, regardless of whether the law authorizes it. Domestic air services, international air services, leases at airports, employment equity quotas, sector charters. It is everywhere, and it has no statutory basis. It is a bureaucratic power grab dressed up in the language of social justice. And the courts are slowly striking it down, piece by piece, case by case, because the law is on the side of those who challenge it. But here is the uncomfortable truth. The courts cannot fix the underlying problem. They can only strike down individual instances of overreach. The underlying problem is the B-BBEE Act itself. It is a fundamentally discriminatory law. It violates the Constitution. It violates the UN Charter. It violates every principle of fairness and justice. And it has failed. After 20 years, poverty is still high. Inequality is still massive. Unemployment is still catastrophic. B-BBEE has enriched a tiny elite, while the majority of black South Africans remain excluded. It has created a culture of rent-seeking, not entrepreneurship. It has discouraged investment and stifled growth. It has divided the nation along racial lines. It is a failure by every measure. Now, the strongest objection to what I am saying is, but apartheid was worse. B-BBEE is a remedy. It is affirmative action. It is necessary to correct historical wrongs. I hear that. I understand that. But let me answer it directly. The Constitution does not permit discrimination as a remedy for discrimination. It permits measures that are reasonable and justifiable. B-BBEE is not reasonable. It is not justifiable. It is not proportional. It is not the least restrictive means. It is a blunt instrument that hurts the very people it claims to help. It traps black entrepreneurs in a system of dependency. It tells them they cannot succeed without state-sanctioned preferences. It tells white entrepreneurs that their success is illegitimate. It tells foreign investors that South Africa is a country where race determines opportunity. That is not a remedy. That is a poison. And here is the final micro-reward. The Pretoria High Court ruling sends a signal to the international community. It says that race-based demands by South African regulators can be successfully challenged. It says that the rule of law still means something in this country. It says that if you are a business, foreign or domestic, you do not have to accept B-BBEE if the law does not require it. That is a powerful message. But it is not enough, because the law itself still requires B-BBEE in many areas. State procurement, for example, is still governed by B-BBEE. The Public Procurement Act of 2024, which has not yet commenced, will align procurement with B-BBEE. That is a mistake. Procurement should be based on value for money, not race. But that is a fight for another day. For now, what you need to understand is this: B-BBEE is not legal. It is not constitutional. It is not compatible with international law. It is a system of racial discrimination that has failed to achieve its objectives and has caused immense harm. The courts are slowly chipping away at it. But the real solution is political. Parliament must repeal the B-BBEE Act and replace it with a genuine, non-racial approach to economic development. One that focuses on skills, education, entrepreneurship and investment. One that does not classify people by race. one that treats every citizen as an individual, not as a member of a racial group. That is the only way to build a truly united and democratic South Africa. Now I know you're angry. You should be, but do not let that anger consume you. Use it. Educate yourself. Share this video. Challenge the narrative. Support organizations like Sakiliga that are fighting this battle in the courts. And remember, the law is on your side. The Constitution is on your side. The UN Charter is on your side. The only thing standing between us and a non-racial South Africa is political will. And that will can be changed, but only if we demand it. So, here is the question I leave you with. If B-BBEE is so essential to correcting historical wrongs, why did the government run away from defending it in court? Why did they not fight to impose it on international airlines? Why did they fold? The answer is obvious. They knew they would lose. They knew the law was against them. And they knew that if the court examined the merits, the entire edifice would crumble. That is why they ran. That is the truth. And now you know it too. If you want to stay informed about the next legal challenge, hit subscribe. Because this fight is not over. It is just beginning. And we will be here every step of the way, holding the line for the rule of law, for non-racialism, and for a South Africa that truly belongs to all who live in it.